putting in 5 caveats. 5 caveats only as the devil's counsel, because a word of caution is all that I'm intending to put in. 1. A statute to regulate the use of AI is imperative. Yesterday, in the inaugural, Brother Mushtaq was insisting that we should, emphasizing rather, that we should have a statute which regulates the AI. Interestingly, I find one of the co-speakers today, Mr. Abhivardhan has put in a bill which says regulation and development of AI 2023. He has suggested it. I stumbled on that while doing some research for this session. And there he has given a definition for AI. AI, to my mind, is difficult to define, maybe capable of being described. But nonetheless, he has made an excellent attempt. But reverting to the position I hold, I do not want to say anything just in case there is a statute tomorrow and there is a challenge to the same. But a very good effort. But most importantly, he has also suggested classification of AI based on technology, content, and he has even suggested a classification based on risk-centric assessment. That
very much, sir. May I now request the last speaker, Mr. Abhivardhan, who's Managing Partner, Indic Pacific Legal Research, and also Indian Society of Artificial Intelligence and Law. We already heard about some of his work. The floor is yours for 8 minutes.
Respectfully, it's an honor to speak in this prestigious forum, and I'm grateful to Justice Sundar for having had a look at AIAct.in. So in my work as a technology law specialist, my concern around AI policy and the way it has been, growing in India and the larger Indo-Pacific was more around that if we really think that regulation is possible in India and we really think that it should be tried, then in principle and practice, what could be the differences? Because a lot is centered around existing legislations, be it in the European Union or China. The discussion is around those issues. But my intent was of drafting AIAct.in was more around at least addressing the problem that if we really think that regulation is possible, then how it would affect the larger AI community in India. What would be the ramifications from a public law angle? Because although not proposed in the draft bill, but it might become necessary in maybe 5 to 10 years that as more public-private partnerships and public interventions using AI technology happens, maybe we need to ensure that the right to information also extends to certain kinds of AI, at least in the public, not in the private side, obviously, not in the proprietary necessarily, but at least in the public sector side, even if it is open source or not. So I will divide my, I would say, insights into 2 parts. First, I will a bit talk about the scene of how AI policy has been in the Indo-Pacific and India largely, and a bit adding to the existing insights in a more interesting fashion. So this is, and the second part, I would be addressing the 2 key topics of this session, which is already around case management and best judicial practices for the country and beyond. So when it comes to AI policy, I was honored to speak and provide my insights in a G20 Brazil Startup 20 technical meeting, in which the questions were around whether the national AI strategies and policies are working out. Now, for any digital public infrastructure, be it in the executive or otherwise, the judiciary is also, a beneficiary of the digital public infrastructure. And we have seen some amazing use cases, especially yesterday, when we saw how the High Court of Kerala's dashboard actually is workable, sensible, and is a good start for inspiration for many high courts across the country. In that regard, I had shared some basic points that, and I think they were more in the administrative side of things, but they also apply in the case of the judiciary. That first of all, there's an AI divide. Now, since the data protection law has already been passed and it will be implemented soon, we will have the data protection rules in a few weeks, hopefully. The one problem is that as the digital divide has already been, the AI divide is also going to affect a lot of, I would say, consumers and citizens alike, because at the end of the day, the role of algorithms itself it needs to be explainable and clear. And while technological explainability is one facet of it, beyond that, there are trust-based aspects as to how you familiarize with any class of technology or the use of data. It's like using basic technologies in India's stack like Aadhaar or UPI or DigiLocker. The more we familiarize with DigiLocker or Aadhaar or UPI, the more we trust it because we understand the limits of what kind of data is probably taking, how it is working, how it is familiarizing. So of course, familiarizing with AI is necessary for every stakeholder, from citizens to members of the bar to even judges and relevant judicial officers and relevant, I would say, stakeholders within courts. So that is definitely a part around AI divide. The other aspect because I was discussing with a venerable judge, I think Justice Padmanathan from Malaysia, and we were discussing about this point that maybe while technological innovation is happening, we really need to think about, in part, not full, maybe decolonizing some part of our systems which are already there. Not merely from a statutory basis, but also from an understanding of how it affects human interactions and how are we creating a trust-based infrastructure. Because having a culture of solutionism is great, which is appreciated, but that may not solve the entire problem because a lot is around maintenance, a lot is around human technology interactions. I think they are minute issues, not so advanced issues, but still they would affect our journey of technology governance, howsoever we use AI in case management and other aspects. To add on that quickly, now I will move on to the 2 points of this session, which are about case management and judicial best practices. So one of the things which I would be happy to propose is that while we need better case management systems in future, we will have them. I think we should try for them. We already have a good ecosystem of people who are trying to understand it. I think knowledge management protocols is a must for every single institution, be it companies, be it anyone. Because the way data quality works, the way data flow optimization matters, and the way certain minute aspects of privacy at across levels comes in, I think that creates a paradigm that we should be concerned about. Another thing which I found interesting to suggest was more around design thinking. So recently, I think I would say the Federal Court of Thailand, or the Supreme Court of Thailand as we say, they actually organized a Justice by Design initiative in collaboration with United Nations Development Program. That was very interesting because it works on 5 key areas. And the 5 key areas are very simple. So whenever you integrate technology or you have a technology-centric management solution, anything, the first is obviously you identify a problem. That's the basic thing that any institution has to do. Second, I think since access to justice is the core fundamental behind any aspect of judicial governance, because at the end of the day, judicial governance is also governance. It could be around a minor aspect around, traffic challans, or it could be at a higher level about certain reliefs, maybe to request to issue writs under the Constitution. So considering that, iteration becomes important. In that regard, empathy is very necessary. How much sensitive are we to the kind of infrastructure or the kind of deliverable we are coming up with? And then, of course, iteration, prototyping, those things come up. But largely, yes, since Justice Sundar referred to AIAct.in, I'll be very quick on getting on AIAct.in. So this act was proposed by my own understanding of how it is happening in India, because again, control and regulation are 2 different things. And while we don't have a larger evolving market understanding yet, which again depends because startups, SMEs, and legacy companies behave differently, even in the case of open source, the necessity to understand and get feedback as to what regulation could be possible was the point. So I classified AI into 4 points, into 4 aspects. First is a conceptual way to do. In substantive law, it could help in intellectual property disputes. It could help in certain contractual aspects, sometimes around phenomenal changes or something around force majeure. The second aspect was around technical methods of classification, to see how technically we can divide and stratify AI. So, one of the ways that the European Union did was general purpose AI. That is a part of the proposal. But others were also included, such as specific purpose AI with specific use cases, smaller access approaches and things, limited use cases, not like a ChatGPT which offers you everything from making an itinerary to making a draft of a petition, because I tried that. Yes. And with that, the two other classifications were commercial methods and risk-centric methods. To conclude further, I think across institutions, when it comes to DPI, in the executive side, in the judiciary side, we really need an evaluated and precise understanding as to how AI or any other digital technology can help us. And I hope that if AIAct.in is something which intrigues all the dignitaries here, I would be happy to, have a feedback of the proposal. And we have already come up with a version 3 in June. We will come up with one more versions. And yeah, it's a pleasure to speak. I'm already